Good evening, everyone, and welcome to another edition of our Justice in Pieces guest speaker series. And today's guest is Rishi Nageshar. Rishi received his JD from my alma mater there, Osgood, last year, and he articled with Walker Law before joining the firm as an associate. He just was earlier this year called to the bar. Throughout law school, he was involved with the Investor Protection Clinic, which was a pro bono clinic providing legal services to harmed investors. And he was the recipient of the Best Advocate Award for the 2019 Bowman National Tax Moot. So Rishi, thank you so much for joining and welcome to the show.
Thank you for having me.
And perhaps, Rishi, you can talk a bit. I know you've just started your practice now as an associate there at Walker Law, but maybe you could tell us a bit about what different things you do at the firm, and maybe a little bit more, could expand a little bit more on your background there about how you got involved and your interest in the law.
Sure. So I primarily practice in the area of civil and commercial litigation. Prior to actually attending law school, I didn't even know what the word litigation meant. So for those of you who that's still a little bit of a foreign term, it essentially means a lawyer that goes to court and argues for their clients. And we deal with a wide range of matters. I've worked on employment disputes, property matters, contract disputes. We've also done some shareholder and investment disputes. But I think the majority of my files right now deal with construction issues. So some of you guys might know this, some of you might not, that in Ontario, there's actually a specialized construction court, and that's because there's special lien remedies and so forth for contractors. So that's why they have specialized judges and quasi-judges, which are called masters. That's also something I didn't know about until I entered into practice. And they deal with construction issues. And that's because I guess it's a very technical area of law. A lot of it is trying to value certain stuff, like how much does someone's work suck, and how do you value that for the purposes of damages? So, and you'll also, one of the things that I've noticed very recently as I started practice is that you tend to have judges who specialize in different things. So, like I said, I primarily practice in civil and commercial litigation, but you might show up to court for a motion for any number of things, but the judge that you might have in front of you might be someone who's primarily interested in family law or criminal law. So you'll have your decision maker, but you also have your specialist, and a lot of the times you have to inform the judge of the law, and that's kind of one of those things that I was surprised by coming into practice, that I've always been under the impression that the judge knows everything and they'll decide whether you're right and wrong, but a lot of the times it's convincing the judge of your case because they're not really interested in your specific topic or dispute.
So you mentioned that before law school there, you didn't know what litigation was. Did you have an interest in law? What propelled you to go to law school?
So I went to law school because, well, I guess stepping back a little bit, I did my undergrad in finance. And one of the things that we primarily learned is that you have all of these rules related to the stock market, rules against insider trading. You have certain market fixing rules and all these really technical things. And when I'd ask my professors, why do we have all these rules? A lot of the times they would say, well, when I was in practice, when I was managing a fund, that's what the lawyers told us to do. So you have to do it. And it was so frustrating to me to think that in a lot of careers, you could go into practice and do whatever you're doing, whether it's in finance or if you go to construction or something like that, and someone in a suit comes by and tells you how to do your job and you don't really understand why. And that's why I found that going to law, that's what motivated me to go to law school, because I feel like if I did, I'd be able to find out the answers for the things that people just told me to do just because. And I'm not sure how much it's mixed into the paralegal courses, but in law school, they taught you a lot about the policy, like the reasons why our laws are the way they are. And that's something that I just, from, I guess, a curiosity standpoint, found fulfilling for law school. And that's really the reason why I went. Why I transitioned into litigation was actually because of my involvement in the Investor Protection Clinic, which was essentially litigation that was supervised by lawyers, and my participation in the moot. And at the moot, I really enjoyed it. I really thought trying to find arguments and advocate for a client, take a set of facts that you might not like, you don't agree with, and try to win a case based on it. And I found that the advocacy was really interesting and really fun. And that's why I shifted my interest away from the securities realm into litigation. And I know you mentioned earlier that the mock trial for Trios is coming up, and I would encourage everyone to participate in it, because when I did that, and I should add that the tax moot, I enjoyed a lot. I actually ended up into it by accident. I was missing a credit. That was a course that had one credit more, so I took it for that reason only. And it ended up propelling my entire career into litigation because I really enjoyed it and I really had fun and I did really well. So I guess with that, I would also add that whoever is watching, I would encourage you to get involved in all of the extracurricular stuff that law school or paralegal school offers, because you never know what you latch onto that launches your career.
So yes, tell me more about the mooting experience there. So before that, I guess you may have had. I know Osgood's the trial advocacy class is very popular, but I don't know if you would have taken it. But what did you learn from that first sort of taste of litigation there in the mooting competition?
So you actually mentioned two very interesting things that I think make my story a little bit funny. Like I said, prior to the moot, I actually didn't know I wanted to be a litigator. I wanted to be a transactional lawyer. So I didn't take trial advocacy. I took the minimum civil procedure courses that we were required to take in your first year. And that was it. That's all I planned on taking. And I didn't do particularly well in that course. I didn't particularly like it. And once I ended up doing the moot, I realized that you can learn all the advocacy skills you would like. You can learn how to question a witness and those things that are typically associated with a litigator, but you also have to learn the substantive law. So you can be an excellent speaker and someone who can go into court and present a case to a judge and cross-examine a witness very aggressively and be confident in your case that way. But each and every case is very different based on the substantive law. So I did the tax moot, and for those of you who have ever looked into it, tax is such a particular area of law, and I knew nothing of it. It really uses different terminology. So one of the things that I learned is that being a litigator does not actually help you be a great lawyer, because there's two parts of it. There's the litigation and there's also the substantive knowledge of the law, and they go hand in hand. And with every file, and it's something that I take with me now in practice, because when I wanted to join the tax moot, I thought I'll just be able to read a piece of paper in front of a judge and be on my way and get my credits. But you really have to learn substantive law behind what you're saying. And it's not always going to be obvious. So when I get a file now in practice, I also keep in the back of my head that it's not simply about scheduling a trial date or a settlement conference in a small claims court and trying to make a case. It's also really ensuring that you do the research to understand your client's position and how you could best advocate for them.
And so you went in there, you became best advocate, and then your litigation career was born. What was the transition like from after law school into starting your articles? Now, I know a lot of law students I've spoken to or recent calls, or even just some of my colleagues who are now 10 plus years out, I'll remark that the first day of your articling quite different than a lot of the policy and theory you're learning. So can you maybe share what that was like transitioning to being an articling student?
Sure. So one of the things that I found particularly difficult in transitioning from the theory of the classroom into practice is using, I would say, it's knowing what you don't know. And part of that is that the courts have been around forever. As some of you guys might know, Ontario adopted its law from the UK. So really we have hundreds and hundreds of years of case law, and our court procedures have been developing over centuries. And that has boiled down to a lot of practice points that nobody really knows why we do it anymore, but we just do it because. And this is stuff that you can only learn by doing and only learn by making mistakes, unfortunately, sometimes. So when I started out in practice, I was very fortunate because I had a very supportive team at the firm that I'm currently working at. They would always review my work and point out stuff that I was missing. But there are things that you just don't turn your mind to, like uh, simple rules of evidence that require you to write things in a certain way. So uh, if you're drafting an affidavit, which you guys might have to, which paralegals might have to do in practice, there's certain ways that you have to phrase your sentences and your paragraphs just to comply with these old rules that nobody really understands anymore. And to this day, I'm like right before the speaking engagement, I was writing an affidavit for a motion, and I subconsciously was writing it in a way that I knew it had to be written, but I don't know if a lot of people knows why. And this is just stuff that you pick up in time and in practice.
And so what did you learn, I guess, over the articling time that you had no idea compared to what you learned in law school, besides writing an affidavit there?
Uh, I think the biggest difference is when I was in law school, and I imagine that it's the same thing for paralegal school, is that on your exam, you would try to put down as much knowledge as you can. You would fire off every case possible, every rule or statute or whatever you can find to say, this is all the knowledge I have, and regurgitate it onto a piece of paper. But in practice, it's the exact opposite. Uh, Judges, your opposing lawyers, your clients, they don't want all of that noise. Your goal, I think, to win a motion or a trial or anything is to simplify your case down into one simple kind of yes or no question. And when I first started out, I remember the first factum that I wrote as an articling student. I did exactly what law school taught me to do, which was show as much law as we can to prove your point. And the first thing that the supervising lawyer said when they reviewed it was, why is there so much noise here? What's the actual issue that we're trying to get at? And that's how I think you win your motions or your cases in court. Simplify it, don't overcomplicate it. Cite as little cases as possible that prove your point instead of throwing everything under the bus and giving the judge a hard time to go through all of your materials.
Now, I guess to the tail end of your articling term, or maybe you got all of it in before the pandemic struck, was COVID-19. Did you get your articling component done before that, or were you already in the process of becoming an associate lawyer before March of this year?
No, my articling overlapped. I think I officially ended articling in May, and the court shut down in March. So that was an interesting transition.
So maybe could you elaborate a bit, and certainly obviously after being called, I think in probably June it would have been, or around that time, you've had to deal with the impact of COVID-19. So what has that affected the business, and what have you sort of gotten to see with a lot of the things being shut down or transitioning to more of an online environment?
Sure. So I'll separate it into two answers, I guess. The first will be clients and the courts. And clients are the more complicated one, I think. We've had clients that prior to the pandemic, if they were a small or medium-sized business, they were very gung-ho about moving their matter forward. I would get an email maybe once a day saying, where are we? When are we going to get a court date? When am I going to get my money? Because of the economic impact of COVID-19, we're starting to see, and it's not just my firm, it's really across the board with a lot of law firms, and I've discussed the same thing with my peers, that a lot of clients are now starting to rethink how aggressively they want to litigate. They're now trying to settle matters, and a lot of clients aren't going to call their lawyer until the very last minute. So as a lot of you might know, there is a 2-year limitation period. What we're seeing now is a lot of clients are saying, hold off on doing anything. Let me try to work it out with the other person on my own before the 2-year limitation period for us to issue a statement of claim, because they don't want to incur the legal fees of having to litigate. And it's unfortunate for, I think, people in my position and anyone else who's listening to this who plans on going into practice in the near future, that the world's very different. Getting people to spend a lot of money on legal fees is going to be very difficult. And really what I think practitioners have to look for is efficiencies, ways to save clients money while getting them results as well. On to the second aspect, it was the courts. So as a lot of you would already know by now, just based on the context of the discussion between John and I, the court shut down very early on in the pandemic. The reason why is, if any of you guys have ever been to the court, particularly the small claims court, it was always a crowd, especially in the civil filings area. You would have process service everywhere. You would have clients all over the place. And it was just not a place where you could help mitigate the spread of COVID-19. So they shut it down. And at first they said, we're not doing anything except for emergency matters. And they defined that by irreparable financial harm or child support payments, possibly a spouse not returning their child, and certain emergency criminal matters. But now we're starting to see what I think is a very positive change. The courts are kind of adopting technology, which a lot of you might know. Historically, the courts were very paper-based. They had boxes everywhere that were full of files and stuff, and it's just not needed in 2020. So we're starting to see a lot of courts using Zoom. I've had a large number of Zoom hearings so far. And what I think is particularly interesting is that judges are trying to maintain the feeling of in-court hearings through Zoom. So in motions court, when I first started practicing and I was attending courts in person, when you went to motions court, you would see what number you were on the docket. You would have the judge or the court registrar say, number 1 on the docket, please approach. We're seeing that they're trying to replicate that in Zoom. So to maintain the structure of the court process while also adopting new technology to help make sure that everyone can avoid the spread of COVID-19, but also it's just easier because now we don't have to charge clients for our time to travel to courts. I can work on a matter and then sign into a Zoom link, and it's a transition that takes 30 seconds from my office, which is now my basement, to the courtroom. While previously, if I had to go to court out in Barrie, for example, it'd be an hour and a half drive. So I think a positive change to the legal landscape in the courts because of COVID-19 has been the adoption of technology that will save clients money, which hopefully will help balance the negative effects of clients not wanting to litigate anymore because of the financial pressures that they're now experiencing.
Now, is preparing for something on Zoom, was that any different than preparing in person? Have you found in your experience with Zoom?
Yeah, one of the things that I've always liked about going to court in person, especially as a very junior lawyer or articling student, is that you will be able to ask other lawyers for help or guidance. And I've visited the courts in Toronto very often, but every now and then I get sent out to a court in Newmarket or Barrie or Owen Sound, and I'm really not familiar with how they do things there. And every court has its own personality, I find. And I find that the legal profession is very collegial, all in all. So I've always felt comfortable approaching another lawyer or senior lawyer while in court and saying, "Hey, this judge that we're appearing in front of, does he or she have a certain preference for the way I approach the bench," or something like that. While I find that in Zoom, it's quite the opposite. So when I was in court, prior to the judge or master entering the courtroom, you'd see all of the lawyers socializing and they'd all get tips and tricks from each other and so forth. And it was a huge benefit to junior lawyers like myself. But over Zoom, I find that everyone is dead silent. No one's really knowing if we could adopt a social aspect that you saw in courts over Zoom. I think part of the reason why is there might be concerns about Zoom generating certain transcripts. While you were in court, you could see that the judge or master wasn't there, and you could have a candid conversation, or you could have settlement discussions or something like that. But over Zoom, when you're not really sure, when you're not able to see everyone who's attending and everyone who's listening, you might be a little bit more reserved in your comments. And I find that for young practitioners, that will be a little bit more difficult. The other thing too is that I remember my first time going to court by myself, and I didn't get lucky, but what I was hoping for is that I would see 2 or 3 other lawyers approach the bench and speak to the master so that I could see what I was supposed to do. I've done the moot, and the moot's academic. I really want to see what it was like in practice. Unfortunately, my very first time in court, I was also the very first person called, so I kind of winged it. But when you when you were able to attend court in person, you could sit back and see 2 or 3 other lawyers approach the bench before you, and you could say, okay, so they all know who this judge or master is. They know how to approach that judge or master without, rubbing them the wrong way. Over Zoom, that's not possible. And every master or judge will host their virtual courtroom however they would like. Sometimes they want everyone to stay in the waiting room and admit one lawyer at a time to discuss whatever issue they want to discuss. And if that's the case, you really lose the benefit of seeing how is this done in this particular courtroom. And I think that that's going to be a rough adjustment for a lot of new calls and new practitioners.
Yeah, I remember when I first started, and I didn't know which side of the court was the Crown, which side was the duty counsel. So who do I approach? And I would just kind of watch for first 10 minutes, and then be like, okay, well now I know what to do and what to say, and then you learn from there. But I guess that's going to be missing. Certainly on Zoom. Hopefully, if you're not called first, you can kind of pick up on that as well. But it probably depends from court to court. What have you found, I guess, since being called? Has there been a difference for you as an articling student earlier this year and now being an associate lawyer in terms of how was that transition like in terms of now being fully licensed, they're fully able to provide advice? And do you find it any different than when you were an articling student?
Yes and no. I've been in the fortunate position, if I'm being quite frank, to work in a law firm environment where some of the senior lawyers recognize that I'm still very junior, that I still have a lot to learn. And for that reason, I still get, I would say, the support from senior lawyers who have practical experience dealing with certain things. But the other thing that you do keep in mind once you become a licensed practitioner is that you now have a license, you now have Law Pro insurance, you now have this responsibility. And it's no longer, you're no longer working for your boss or your employer or your law firm. You're working for your client and you have to meet their expectations. So I find that really the transition from being a student that was working under a practitioner was that I was kind of seen as a student or apprentice or an intern. But now I'm seen as a practitioner who's supposed to deliver the results that my clients want. And it's a new level of responsibility that I think perhaps it's somewhat imagined and created based on, the speeches that you hear at the Law Society and the oath that you take and so forth. But I think that if for those who really truly care about being a practitioner, the transition of having your own license creates a whole new feeling of responsibility, if not responsibility in and of itself.
And I can certainly share this because my brother was called earlier this year, and I guess there was the missing element, and it's unfortunate for you as well that you don't have the big ceremony that you have that kind of feeling of, okay, now I'm being called and walk across the stage and get my I don't know, sort of diploma, but basically your license. It may have been a little anticlimactic with, I don't know if they just put it in the mail or you got an email, or I think my brother said he got an email. It's like, oh, by the way, you're a lawyer now. So how was that how did you deal with that? Or did you have a different sort of process of getting the news that you're now able to practice as a lawyer in Ontario?
Well, I was a little bit lucky. So I started my articling much earlier than most students. So most students will finish law school in, I think, May, and would begin articling in early August. I started articling 1 or 2 weeks after law school. So I was licensed very, very early compared to my peers. And I knew that the ceremony, if there was going to be one, would be at the same time with my peers. So I was a lawyer for quite some time before the ceremony and before receiving those certificates. And I did receive the certificates in the mail, but I guess maybe because of the lack of the ceremony and the celebratory aspects, I haven't even, framed them yet. They're still in the envelope that I got them in. I hope to return to the office one day and maybe I'll hang them up there. But a small benefit that I've found, and I think that a lot of my peers are taking advantage of as well, is that when the courts transitioned to using Zoom, and a lot of the judges and masters are no longer in courtrooms, they are doing hearings from their house or from wherever they're spending their time. One of the changes that they've done to accommodate judges and masters at home and lawyers in practice, and I guess it's also a result of being seated while you're on Zoom as well, that they no longer require you to wear robes. So it's now just business attire for judges, masters, and lawyers. And for a lot of the new calls, because our ceremony was canceled and because we're not required to wear robes in court anymore, a lot of us have saved the money of buying robes. For those of you who don't know, lawyer robes are like $1,500 for what looks like a curtain. So I've been very happy about saving the money on that. As soon as they change that rule, it's going to be a bad day, but I'll deal with that when I get to it.
I'm sure if I dig up my rope somewhere, there probably no way that they fit still. But a few times after being called, it was in Superior Court there, but otherwise they're collecting dust somewhere there. So a good savings there in the pandemic, I suppose.
Yeah, I'm hoping that's a change that they make permanent, because the United States, I don't believe they use robes. The UK, I think their robes are much more complicated, and we've kind of adopted an in-between position. But I'm hoping that once everything returns to normal, if it ever does, I really want there to be a judge that says, what are we doing here with these robes? Can we kind of get rid of it? Lawyers are wasting 10, 15 minutes of their days getting in and out of these whenever they have to attend court. Let's just save everyone the time.
Now, another thing, I guess, with the transition there is that as a junior lawyer, and certainly maybe as well as an articling student, that you're going to get a lot more experience for the first time. A lot of things you're going to be doing that you didn't have an opportunity to do before. And I think one of the things you were mentioning to me before we started here was, you do a little bit of some of the small claim files related to some of the bigger clients you may have, that they may have a few things that go there. What's that like compared to the Superior Court for the civil litigation ones that you've worked on? Like, how would you compare the two different aspects there?
Sure. So in theory, and I want to emphasize that in theory, the small claims court is designed to be a more simple process that's more streamlined and that's more easy to understand, so that everyday people can enter that system without hiring a lawyer or paralegal. My personal experience so far is that the small claims court is quicker. There are less steps until you proceed to a trial, which is generally the final step. But I don't know if I actually find a small claims court to be more simple, because they're much more structured in the sense that their forms are very detailed. So for the Superior Court, when you're drafting a statement of claim, which is the document that commences a lawsuit, you can write whatever you want in there. There's a preamble, and that's it. It's a couple paragraphs that the court wants every person who's getting sued to see, and the rest of it you can kind of free for all, write whatever you want. Small claims court forms, on the other hand, are very structured. They're very detailed, and there's a layout to the way that you're supposed to fill in all of the information. So I find that the small claims court, while it's supposed to be a little bit more streamlined, it's also something that you have to just learn by doing. And I think practitioners who spend a lot of time there get very good at it, while practitioners who want to start out at the Superior Court find it a little bit easier, because they can change their documents and amend it and kind of work as they go. The other difference that I've found is that small claims court masters and judges are very interested in fairness. And with that, they deviate from the technical law to some extent. Like, obviously, you're constrained by the case law and statute and so forth, but a lot of what the focus is what's fair for the people that are here. In the Superior Court, we're more interested in what's the law, what's the statute. So you could be the same lawyer that has the exact same facts of the case and maybe even the same parties, but how you will approach something will differ based on whether you bring that matter into the Superior Court or the small claims court. The small claims court, you want to focus on fairness. You want to focus on why citing what your client is the right thing to do. The Superior Court, you really want to focus on citing those precedents that are relevant.
I think that I did miss in the transition there is the licensing exams, the barrister and solicitor exams. And, some law students obviously have a lot of anxiety about what that process is like. And perhaps maybe you can share your experience with those exams.
Sure. So I'll speak to, I think, three different kinds of exams. And the first was my exams. So when I did it, it was 2 days, 2 weeks apart, 7 hours a day for exam writing. It was brutal. And that's not the way that exams have been written this year. So I did speak to some of my colleagues that were writing the exams this year because I was curious about what their experience was, and they're writing exams over video conference. There would be a single proctor and about 4 or 5 people taking the exam, and to me it's very odd. I think one of the things that make the bar exam one of the reasons why I think a lot of students pass the exam, and for those of you who don't know, the Law Society doesn't release the pass-fail rates, so nobody really knows what the pass-fail rate for the exams are. So if you were to ask me, hey, Rishi, was the exam difficult? I would tell you, I really don't know. If I got 100 on the exam, it was probably pretty easy. If I passed by 1%, I'd probably say it's very difficult. Where do we land with that? I'm not 100% sure. But what I would say for those of you who are kind of curious about practical tips is that you should trust yourself. If you've read the materials, and you'll see a lot of people give different tips, and one of the tips that I got was read the materials 2 or 3 times. I didn't do that. I read it once for the stuff that I read the materials once for the courses that I took in law school, and for stuff that I didn't take, I read that and I may have reviewed the parts I found confusing. So law school and paralegal school, they prepare you very well for what you're going to be examined on. So if you reviewed something in law school and you're reviewing it again in preparation for the exam, you're probably pretty set. Again, that depends on, everyone will have a different approach to that. And so I mentioned that there was the in-person examinations, there were the virtual examinations, and paralegal examinations. And there's a paralegal at the law firm that I work with, and she was doing her examinations several months after I did mine. So her and I talked about strategy. And what I shared with you is largely the feedback I got from her as well, that read your materials, trust yourself, and you'll be okay.
And so, as you just mentioned, paralegal there at your firm, what kinds of roles that they play, and how do you work with the paralegal in terms of your, let's say, day-to-day interaction? I know it's a little different these days, but what are the different responsibilities that maybe you could share at Walker Law that they would be doing?
Sure. So fortunately, I think at our firm, we have a lot of flexibility over our career paths. So the managing partner, Tanya Walker, you guys should all look her up, amazing lawyer. She supports many different types of career paths. So I've gotten support in regards to what kind of litigation I want to go into. If it's something a little bit different or unorthodox, we'll make it work. And that's the exact same thing for paralegals. And I believe that this is also the experience for a lot of paralegals at other firms as well, where you can choose your career path based on what interests you. So one of the paralegals at our law firm, she never wanted to go to court. She never wanted to ever make submissions, never wanted to attend a landlord and tenant board, because speaking just wasn't her thing. But she was an amazing writer. She was an amazing researcher. So for all intents and purposes at our firm, she was a lawyer that just didn't do the speaking part at court. She drafted materials. They were excellent. She's helped us win tons of cases because that's a career path that interested her. The paralegal who took the exams last year that I was referring to, she, on the other hand, wants to be, I guess, more of your typical practitioner, where she would attend a small claims court for our clients, attend a landlord and tenant board to actually do arguments and make arguments. So the kind of career path that is available to paralegals and lawyers, I don't think it's fixed. I think in my experience anyways, law school always prepared us for the typical private practice lifestyle and workload. but that's not really what you're restricted to. If you know what you want to do and you're good at it, you'll find a place at a law firm or a company that really wants the skill set that you bring to the table.
Thanks for sharing that. That's just like, glad you mentioned that about the paralegal there, and I wanted to definitely relate that to my students. Other than maybe the practice side, what other, I mean, maybe things like interacting with clients or docketing or uh, note taking. What else have you found a little bit unique, maybe in the day to day work as an associate lawyer or as an articling student?
So uh, at our firm, paralegals and lawyers use the exact same software. We bill clients the exact same way for work that's done, and we bill 6 minutes at a time. So it's really interesting, and that's my understanding is that's standard across every law firm. Like that's very standard in the legal industry. So it's very interesting to go from academia where you're studying and you just say, well, I have to get this done, and however I do it, that's fine, to docketing your work days in 6 minute increments. So it's interesting because it forces you to be very efficient with your time. It forces you to track your time. One of the things that you mentioned that I thought was interesting was note taking. And note taking when it comes to everyone is so important. What I mean by everyone is other lawyers, judges, opposing counsel, and your own clients. And what a lot of you might be thinking about currently, depending on where you are in your studies, is that there is such a thing as law pro claims. There is such a thing as law society complaints, and that often happens from your own clients. And it's, there are some cases where there's just a bad lawyer and there's just a bad paralegal that does something that's blatantly wrong. A lot of the times, however, it's a situation where the relationship has deteriorated, where there was miscommunication and something went wrong, or you misunderstood your client, or your client gave instructions that they didn't understand what they were saying, or sometimes they just forgot what they instructed you to do. And when you end up in that situation, and that client might want to make a complaint to the law society, or might try to instigate some sort of proceeding where you would have to go to your law pro insurer, you really want to make sure that you have note taking to protect yourself as well. And it's difficult because as a lawyer or paralegal, one of your primary interests will be your client's best interest. That's what you have to have in mind at all times. You can't do anything that's self-serving. You can't do anything to help the other side to the detriment of your client. And you and your client have to be on the same team, but you also have to keep in the back of your mind that should the client one day wake up and not be happy with the way things are going, you also need to protect yourself. And that's why note taking, docketing, and stuff like that are very important.
Another thing that we've been talking a lot of with the lawyers and paralegals and others here is we certainly with COVID-19, it maybe draws a more highlight to it is we have a very stressful profession, right? There's a lot of demands, a lot of work, a lot of deadlines. What have you found as maybe a mechanism for you to have some time and deal with ensuring that you have your mental health taken care of and you're able to relax and find a little bit of a work-life balance, especially during a pandemic where social interactions are limited? What have you found has been a good tool for you to kind of make the transition and find some time for yourself as well?
So I think I'll split that into 2 points that I think are very important. The first is the policies at the law firm you work for. And I think a lot of people who go to law school or who go to paralegal school, they're going to be type A personalities, people who are very motivated, they work very hard. And I think part of a type A personality is, prior to working for Walker Law, I was the type of person that I never took vacation. I would instead ask for the vacation to be paid out so that way I could constantly work. And that's just the way things were. When I joined Walker Law, I learned that we don't do that. And the reason why we don't do that is because if you're never taking a break, you're going to burn out. It's too difficult to work all the time. So really finding the time to get away and really getting away as well. So once you enter practice, if you want to take a vacation, make sure that do practical things like, use your Gmail or Outlook reminders that tell people who email you that you're out of office and on vacation. Find another practitioner. If you're a sole practitioner, this could mean a friend or a colleague or someone, but find another practitioner to manage emergencies for you. So for me, it would be one of my coworkers. If I would find 10 minutes a day, every day when I'm on vacation to read my emails. And if it was an emergency, I would forward it to another lawyer and say, please deal with this while I'm away. And make sure you have that arranged beforehand. Don't surprise one of your coworkers because they're not going to be very happy to help you in that situation. But find time to get away and make sure your time away is really time away, because you will burn out. The legal profession, whether you're a paralegal or a lawyer, it is very intense. It's very high stakes. There's a lot to manage. So make sure you're also managing your own mental health as well. And I think that's really what I would say from the law firm perspective. From a personal perspective, I think it's important to find a cutoff, and everyone has a different approach. Some people say work-life integration is the best way to go. So find a way to integrate your at-home life with your work life so that you get the best of both worlds. I've personally always been someone that when I do that, everything just kind of gets messy. I'm not really working and I'm not really spending time with my family if I'm mushing it all together. So I like to find time to step away. And on a personal note, what I think is very important is to find something to look forward to at the end of every day or at the end of the week. So it could be something simple. Today, I found out that my favorite sitcom was added to Amazon Prime, so I'm going to make it a habit that at the end of every day, watch one episode of this sitcom, and that's something to look forward to, and it's just a way to keep your motivation up. The other piece of advice that I got when I was in law school that I keep to this day because it was so important was actually from Benjamin Berger. I'm not sure if you knew him at the time, John, but the advice that he gave was know when you're not being productive anymore. And sometimes you could be so stressed and so tired or so deep into a file where you're not able to see a solution or see an answer, and recognize once you've reached that point where when you're no longer helping yourself or helping your client. And once you've reached that point, step back, take a break, or maybe put the file off until the next day. Because at some point in time, I see a comment from Bryce, diminishing returns, that's exactly what it is. You're just not as productive anymore. And being able to recognize that in yourself is very important.
Right, so just maybe before we transition to the end here, if any of the students have any questions, if you either want to pop them into the chat or if you want to just unmute and ask Rishi, feel free to do so at this time. And I think Bryce has a question here.
How exactly are paralegals going to get that little opportunity to start talking to people and move things around? I feel like there could be a hole for some sort of video chat groups. Have you been hearing any buzz about that?
Yes. So
really?
Well, not necessarily for paralegal groups
specifically. Yeah.
So, but I think one of the things that you'll take into practice, and that goes for everyone in your cohort, is that the people you went to school with, they're going to be your peers for a long, long time. So I graduated from Osgoode. I think it's probably the biggest law school in Ontario. So I was very fortunate to have a very big cohort. And whenever I get stumped with something, I will ask one of my colleagues. And it's, like I said, the legal field is very warm in certain ways and very aggressive in others. But when it comes to helping out your peers, you'll find that there's a lot of support out there. The Law Society also hosts like mentorship programs. Be sure to register for a lot of the legal societies and groups, because there's a ton of them out there. There's the Toronto Lawyers Association, the Advocate Society, and the Bar Association. So whether or not you practice in Toronto or go somewhere else, I almost can guarantee you that there's a local legal administration. They will be your best friends. And you'll be able to find a mentor and they'll be able to help you out. The other thing too is just, like I said very early on, that there's times when I would have to go out to court in different areas. I'm not sure if you're aware of this, but there's a rule that says you technically have to sue someone in the jurisdiction that they live in. So if one of our clients want to sue someone in Barrie, I have to go to Barrie. But
Yeah.
But because of the size of my network, just based on talking to people whenever I go to court, or my law school network, I could email a friend that I know practices in Barrie and says, hey, what am I walking into tomorrow? And you're probably going to get a result. And part of that is also maintaining a relationship with people. You want to be someone that people want to help. And that also means reciprocating when people reach out to you.
Yeah. So instead of like courtroom antics, it's more of like, water cooler rather. It's more like student water cooler that has grown into a network is what we're going to be doing versus what you had the opportunity to have for
That's
a brief
exactly
time
it.
during when you're okay. Cool. Thank you.
And another one of the ways that I've met people, and I know it's odd to think of it this way, but you're going to be required to take your CPD requirements, and you're going to be put in a room full of your peers. Make sure you socialize with everyone. It's something that's so simple but so important, because that will be your support network once you get stumped with an issue that you don't know the answer to, but they might.
Perfect. All right, so Rishi, thank you so much for taking the time and joining us here today. I really appreciate you coming in and sharing your advice there from law school to articling student to now an associate lawyer. So a lot of progress, and especially during these challenging times. Perhaps if you have any final words of advice for my students who are looking to make a transition into the field within the next year of now, certainly I know you're a lawyer and you may not have as much experience there with the transition for paralegals, but what can you share about maybe from your experience there in terms of advice of going from a student to now being a full-fledged lawyer in the last year and a half or so?
I think the most important piece of advice that I can give you, and this is based on the mistakes that I've made, is that when I first started into practice, the very first assignment that I got was to draft an application record. And I did not do very well on it. And the reason why I didn't do a good job drafting this is because I didn't ask anyone for help, and I didn't ask anyone for advice. You have resources out there. Use every experience as a learning experience. I could also tell you that every time I've ever been in court and I've kind of rubbed a judge or a master the wrong way, I've also walked away learning something as well. So in every experience, positive or negative, that I've had so far, this second or third time I've done it, I said, well, last time this judge wasn't very happy with that. So let me keep that in mind. And it's a learning experience. So once you get into practice, the learning curve is so steep and it's so difficult, but it's not something that's insurmountable. Ask for help. People will help you. If a judge or master in the small claims court or at the landlord and tenant board indicates that they disagree with you on something, ask them why, and you'll learn something. So have an open mind, use every experience as a learning experience, and don't take anything too hard. It's not something that anyone gets automatically. I know that when I first started practice, I thought, how is this lawyer who's 2 or 3 years out doing a full trial by himself or herself? But it just comes in time. You'll get there.
Perfect. Thanks so much again, and wish you all the best as you grow in your career here, and certainly and I think you're under the tutelage of Tanya Walker there, so I think you're getting a lot of great experience there, and I wish you all the best.
I'm in good hands. Yeah. If your students have any other questions, they should feel free to reach out to me. I'm happy to talk a little bit more. Like I said, the legal field, I think, is very good at helping young lawyers and young paralegals transition and move forward.
Perfect. Yeah, if you have any contact details, I can pop in the chat there for them if they want to reach out to you and get some further information, or I guess you can do it too.
Perfect. It doesn't look like the chat feed. Oh, there it is. So I'll just leave my email address there, and whoever wants to reach out to me, by all means.
Sounds good. So thank you again, Rishi. Thank you everyone for taking the time to join us today. And we'll see you tomorrow at 5 o'clock as well. Take care, Rishi.
Thank
Good
you,
luck, everyone.
Rishi.
Thank you.
Thank
Thanks.
you, Rishi. Thanks, JP.
Bye,
Bye,
everyone.
everyone. See you
Thank you.
tomorrow.
See it.